But at the same time, this African Commission is the creation of states, is the creation of an intergovernmental organization, which in a sense then would be influenced and would serve also the interests of the state. So as much as you have an independent institution, you have a state-based context within which it functions. And I think it is within this that I locate my discussion. So if we look at the Charter, perhaps it's unnecessary to say this, but the African Commission is certainly set up as an independent institution. We have that in Article 31, where it is made very clear that the commissioners serve in their personal capacity. We have it in Article 38, for example, where it is clarified that the commissioners will swear an oath of impartiality and independence. And clearly we also have it, if you like, in Article 45.3, where the function of the Commission is, among other things, to interpret the Charter on the request of states. So if you look at those, the Commission certainly has been set up as an independent, autonomous body to protect and promote and protect human rights. But at the same time, the Commission members are elected by the Assembly. So state parties elect the Commission, and they, as the Assembly, have the hold of the purse. Article 44, the budget is provided for by the states. So I suppose, in a sense, you know, certain tensions may potentially arise from this kind of a paradoxal dichotomy, if you like. But one would also have to take into account what the Charter says in Article 59. So what the Commission then is required as an independent autonomous body is to report, at the very least, to its political masters, to the Assembly. Article 59, the original version, says that the Commission has to report to the Assembly, and the Assembly will consider its reports. So Article 59.3 says the reports of the activities of the Commission shall be published by its chairman after it had been considered by the Assembly. So, in a sense, the story for me will resolve to some extent about this word consider. What does it mean that the Assembly has the competence to consider the Commission's reports? In this regard, I think it's important to just at the outset also distinguish between the Commission's work that is promotional, as we know, and the protective work, because for the protective work, Article 59 tells us that the protective work stays confidential until such time as it is published. But the implication is that the promotional work, for the promotional work, there is no such a stricture in terms of publicity and confidentiality. Article 59.1. If there is a potential tension, for many years I think it's fair to say that this tension did not really present itself. The Commission was working from the outset in 1987, 88 as an independent body, and it reported to the Assembly, and perhaps more out of neglect than a constructive engagement, the Assembly allowed the Commission to present its report without much criticism, critique, or even discussion, as far as what one would have noted from an outside perspective. So, as much as perhaps the Commission had been allowed to pursue its agenda, there was also, if one likes, relatively a low level of political buy-in from the Assembly in terms of supporting beyond rhetorical commitments the work, the implementation, for example, of the Commission's findings or decisions. This, in a sense, changed when the OAU became the AU. After a few years, the function set out in Article 59 to consider the reports of the Commission was delegated by the Assembly to the Executive Council. And with that also there was the requirement of shortening the report of the Commission. So this meant, in practice, that for the first time really there was a very, very clear and constructive engagement from the political organs, from the policy organ side, when they received and looked at and considered, if you like, the Commission's report as one sees it. It also meant that the PRC, the Permanent Representatives Committee, which as a general rule works on and prepares the agenda for the Executive Council, that it became much more prominent and important in this whole process. because when the Executive Council took the role over to consider the reports, it allowed room for the PRC to prepare the kind of contributions. So there was this two-layered contributions made on the activity reports from the PRC and from the Executive Council. Now I always think that this almost sets up the Commission for a collision course, because the PRC and the Executive Council by definition consist of diplomats, people who are either ministers of foreign affairs or diplomats who see the world from the interest of the state perspective, as opposed to the Commission that has been mandated to deal with the law, if you like, the law of the African Charter and how it is interpreted. So, in a sense, it's almost predictable that there would be great contestations from discussions by these two different entities, and I'm sure that the Commissioners will speak to that. So, since the Executive Council then took up a much more prominent role, before we get to the instant situation around what is called this Decision 1015 of the Executive Council concerning the coalition of African lesbians and observer status, may I just for a moment take a step back and say that that was certainly not the first time when the Executive Council commented on and pushed back on the activity report of the Commission. I've noted in 2004, perhaps the first specific instance, when there was a fact-finding mission to Zimbabwe. The Commission published in its activity report its findings on the fact-finding mission. Zimbabwe, when this report was discussed, noted the concern that its comments had not been taken on board. The publication of the activity report, which was the 17th activity report, was then suspended for the comments of Zimbabwe to be solicited and added to the report, and the report was thereupon published. Something similar happened also in January 2006, when resolutions, country-specific resolutions, were adopted against or in respect of 5 countries: Eritrea, Ethiopia, Zimbabwe, Uganda, and Sudan. These resolutions were referred to in the activity report. The states then contended that they had not had a sufficient opportunity to respond to these resolutions adopted by the Commission. The activity report was then published without the resolutions contained. States were given 3 months to give their comments, and a kind of an addendum of comments by the states was subsequently published. Now, these obviously relate to the promotional mandate of the Commission, and in the Commission's rules, there certainly would be processes indicated in terms of which the comments of states would be solicited. So, if you like, for the mission report, the Commission, in a sense, bent backwards. For the resolutions, perhaps there was actually no specific opportunity granted to the states to respond. A while later, there were 2 decisions. A decision taken against Zimbabwe, June 2006. And again, in this case, Zimbabwe argued, the government argued that it had not been given a sufficient opportunity to respond to the allegations in the communication. Now, clearly, I would say that that was, in a sense, outside of the applicable rules to make this objection, because the Commission, as we know, allows opportunities for states to respond to allegations, and there is a system that is prescribed in terms of which the states have an opportunity before the ultimate decision is taken. Notwithstanding, the government was provided an opportunity to respond to the decision, and the response was then later published. Perhaps most disconcertingly, in January 2015, from what one could gather, 2 cases against Rwanda, which apparently had been decided, were expunged from the 37th activity report because of objections made by Rwanda that it had also not had the sufficient opportunity to make oral submissions in respect of this case. These are all, in a sense, procedural issues. The states objected to not having been included sufficiently in the process of the Commission arriving at a particular outcome, whether it was a resolution, a fact-finding report, or a decision. So in that sense, I suppose one can say that the Commission's independence substantively had not really been affected or threatened or compromised by the, if you like, the accommodation of the state's views, the withholding of the publication for some time, or the inclusion of the views and the withdrawal, I suppose, here of the cases, though seem to be a bit difficult to explain. However, what happened in June 2015 and subsequently is now different, I would argue. In June 2015, as you may know, the Commission at the time accorded observer status to an NGO, the Coalition of African Lesbians, based here in South Africa. It was a narrow vote, but be that as it may, the Commission accorded the status, and it then reported to the Executive Council, as it would, in the middle of 2015. And when this report was considered by the Executive Council, I would say that for the first time the Executive Council then took a view that essentially reversed, not just procedurally making an impact, but reversed requested the Commission, directed the Commission to, I don't know, ungrant or withdraw the according of observer status to the Coalition of African Lesbians, as I'm sure most of you know. Just to make that, at least as I understand, the distinction between why what happened in June 2015 when the Executive Council directed the Commission to withdraw the status, I think was the first time that there was a specific attempt to substantively come to a different outcome than the Commission had come to in its own interpretation of the Charter's provisions. You may know that after that there was a request for an advisory opinion to clarify this issue of what considered in Article 59 of the Charter means, but it was ultimately found to not be a matter to be decided by the court because of the lack of standing of the parties that brought it. The Commission for those years, if you like, suspended its decision on this matter, so that no decision was taken by the Commission in response to the direction, if you like, by the Executive Council. On occasion, at least in January 2018, the Executive Council once again reiterated its directive to the Commission to withdraw the status according to the coalition. And in addition, he called for a retreat. As you know, the retreat was organized between essentially the members of the Commission and members of the PRC that took place in Kenya. And a report was issued after that retreat. I don't want to go into the content because I think it's not necessarily all publicly available. However, the outcome of that process was that in June 2018, the Executive Council adopted this decision 1015. In 1015, essentially, the Executive Council gave an ultimatum to the Commission to withdraw the status before 31st of December 2018. And to cut a long story short, the Commission soon thereafter, meeting at an extraordinary session, I believe, then actually wrote a letter to CAL and withdrew the status that it had previously accorded to CAL. So the bottom line, and an issue that has a very serious concern among civil society, is that on those facts alone, the Commission's ability to act independently, autonomously, in terms of its mandate, had been compromised because it had to, and it did, give hierarchical weight to the directive by the Executive Council, which is the policy organ. However, if the resolution or decision 1015 only spoke to the issue of the withdrawal and the restoration of the non-withdrawal, if you like, it would have been a different matter. But the Executive Council then used the opportunity to adopt a relatively lengthy decision in which it entered into various other domains, as I'm sure many of you know. And I will briefly state some of these issues. First of all, it observed that the Commission is only functionally independent and not independent from the other AU organs, the policy organs. It does not explain what it means by that, but it made the point that the Commission may function independently, that it has functional independence, but it is not independent from other AU organs. Secondly, it said that the process to clarify the Commission's status as an AU organ has to be accelerated. I think, as many of you would know, the Commission is not mentioned in the AU Constitutive Act, for example. It is not there as an organ of the African Union. There was a subsequent decision by the Assembly that said that the Commission functions as an AU organ. But that was the closest the Commission became to being an AU organ. It was by resolution of the Assembly that said the Commission functions as an AU organ. So the request or the direction from the Executive Council was then that this matter be clarified, that the Commission's status as an AU organ be quote-unquote regularized as soon as possible. The third issue that the Commission, the Executive Council decided was that it expressed concern that the Commission is acting as an appellate body that undermines the national systems. So perhaps that relates to issues around exhaustion of local remedy, where the states do not fully understand the role of the Commission as not being an institution of fourth instance. But be that as it may, in the decision expressed was a concern about the Commission acting as an appellate body that undermines national systems. And then lastly, in terms of the general decisions taken, it said that it understands the Commission as acting as an audit mechanism. Again, quote unquote, that is the role of the Commission, to be an audit mechanism, to audit human rights in the African Union system. It also just generally reinforced the position around this coalition of African lesbians by saying that the Commission must align all its activities with the virtues of African tradition and the values of African civilization. Perhaps harking back to the issue around sexual orientation and gender identity that may have arisen in the context of the coalition of African lesbians observer status request. So that is kind of the framing of the decision 1015. And then in the decision, the Executive Council calls for certain specific reforms. It calls for a review of the guidelines that the Commission had previously adopted to give observer status to NGOs. So it was not only the CAL specific issue, but the guidelines themselves that needed to be revised to better capture African values, quote unquote. Secondly, the Executive Council directed that the rules of procedure should be revised to clarify all ambiguities that may exist. As you may know, that there has been an ongoing process of revising the rules, which in a sense I think is coming to a process of culmination. Public knowledge is that there is a call for public contributions to a set of revised rules of procedure that is on the Commission's website, and the date for that is the 26th of September, just to put that in context here. So the review of the guidelines for NGO observer status, the review of the rules of procedure. Thirdly, a code of conduct should be adopted by the Commission. Talking also of issues of impartiality. Then fourthly, a set of guidelines that would regulate the Commission's engagement with external actors, presumably donor community. And then lastly, in terms of specific actions required, the Commission was required to do an analytical review of its protective mandate. And what reads in there between the lines is that there's a kind of an expression of concern. Why does the Commission still have to have a protective mandate while we have the court? So the issue here is justifying the existence or the kind of continuation of the Commission's protective mandate, communications mandate, in the light of the complementarity that exists with the court, and then also asking about the possibility of conflicting jurisprudence between the court and the Commission. So this is like one packet of an analytical review looking at, if I read it correctly, basically asking the Commission to justify why it should continue having a protective mandate in the light of the fact that the court is there and has a full protective mandate. The decision 1015 also makes some general calls calls to the Commission, not in terms of these very specific outcomes, but it says generally that the Commission must give attention to all rights. So the emphasis on all. In other words, there's a suggestion that the Commission is overemphasizing or drawing attention to some particular rights at the expense of others, and that should be rectified. Disconcertingly, in my view, it also observes the Executive Council that the Commission must observe confidentiality at all stages of its work, in line with Article 59. And that clearly, I think, must mean that it's just, I don't think the Executive Council can overrule Article 59.1, which says that the confidentiality pertains to the Commission's protective work, rather than all aspects of its work. I think the practice of the Commission is that the only aspect of its work that is confidential is the protective aspect. That remains under wraps until this is published, but the other aspects had routinely become more in the public domain. But the Executive Council says, quote unquote, the Commission has to observe confidentiality at all stages of its activities. But it says in line with Article 59. So perhaps one can say that invoking Article 59 there puts a qualification on the statement of all stages. The last aspect I mentioned here is that the Executive Council also then requested the Commission to verify and apply due diligence before publishing any allegations against states in its activity reports. So that there should be more engagement with states through processes of verification and due diligence before any allegations are published or made public in the activity reports. I think one may just pause here to say that, especially in the last, decade or so, the Commission's work in the two fields has really mushroomed, and that is in the field of urgent appeals. So urgent appeals directed at states, and the idea of urgent appeals is that there should be an immediate response. It's directed at the head of state, so there should be an immediate response, an allegation of someone who's tortured, is disappeared, very serious human rights violations. By definition, the Commission's understanding, as I have it, is that these urgent appeals do not allow for an opportunity to engage before making the urgent appeal. The urgent appeal is exactly the process of getting the state to respond to allegations which are to the knowledge of the Commission. But these urgent appeals contained in the activity reports of the Commission has certainly been a cause for concern or I think pushback on the parts of the state. So I think this observation by the Executive Council speaks specifically to these kinds of allegations, that there's a sense in which the states would want the Commission to apply due diligence and find verification of the facts before even mentioning an appeal to the states. The second aspect of the Commission's work that had, I think, quite mushroomed is its adoption of precautionary measures, interim measures. A state like Egypt, for example, in the context of the imposition of the death penalty and fair trial rights, huge numbers of provisional measures have been taken in respect of Egypt. And the response of the state has always been negative in terms of not complying, not seeing itself complying with those measures. May I just add, and I'm almost done, that the subsequent report in February 2019, and the one before that, the 45th and the 46th activity reports, one sees an interesting trend where the Commission, when it publishes its activity report, it publishes separate sets of comments by states. So in the 45th report, for example, there's responses by the Algerian government attached to the activity report. And to the 46th activity report, there are responses attached by Algeria, Egypt, Zimbabwe, Gabon, Nigeria, and surprisingly Morocco. So that seems to then have been a new kind of trend that has evolved very specifically. In its latest round of decision, the February 2019 decision that I have access to, following up on the 10-15, the Executive Council noted that it took note of the fact that CAL's observer status was terminated, if you like, but it specifically called on the Commission to not in any way further cooperate with CAL. It also requested the Commission to, in each of its activity reports now, report on each of the elements of this Decision 1015. So to say what is the progress on each of the reviews and so on that had to be undertaken. It then also says that it will institutionalize an annual retreat process. So there will be an annual retreat between the commissioners and the political policy organs, the PRC, by assumption. It also says that the names of commissioners must be indicated in the activity reports, and the activities related to the activity report which the commissioners are responsible for should be identified, so that the states apparently can see which commissioner would be responsible for which specific activities. So, as much as I think the issue around Decision 1015 relates to the specific NGO and its observer status, I think there are some, perhaps like myself, who think that that to some extent was a smokescreen or a ruse, at least for some states. It was an opportunity to galvanize kind of emergent resistance against the Commission among some states. It was an issue, sexual orientation, gender identity, that clearly was easy to make a rallying cry around, that got states to be subscribing to the pressure of the Commission. But for states like Egypt and others, I'm clear, you know, the thing was that they found the Commission to be an increasingly painful thorn in their flesh because of the kind of very specific activities of the Commission in terms of its mandate and in terms of, in particular, the provisional measures and the urgent appeals. Well, that is, in a sense, my interpretation, so certainly it's open for discussion. So I think it's a culmination of various events that, of course, the Executive Council to actually take the course that it had in June 2018 in June 2015, namely to ask for the reversal of the Commission's decision, and then in 2018 to actually go one step further and reiterate this, put an ultimatum, and really make it a much broader kind of set of issues which the Commission has to, in a sense, account for. So the sense is that the Commission, in a sense, is certainly under some sense of siege, that it has to justify its existence in terms of its protective mandate, that it has to incorporate the concerns of states, and in particular react to this amorphous notion of African values, virtues of African tradition, and how to incorporate attention to all rights rather than specific rights. So what the Commission has done so far, as far as one knows, I'm sure others can complement, is that it has divided itself into, let's say, subcommittees. It is obviously looking at the various issues of concern, preparing responses. There has already been a revised version of the guidelines for NGO accreditation, which I think was still very fine from a civil society perspective. But I think it's an ongoing debate between the Commission and the policy organs as far as that is concerned. So maybe just in conclusion, apart from Decision 1015 and all of what it encompasses, there is the general issue just about the kind of non-implementation of the Commission's findings, the concern that the Commission has expressed on many occasions about its decisions not being very consistently implemented in practice. It is true that we have not really seen many states explicitly negating kind of the potential of the Commission's findings, for example, arguing that they are not binding. We know that Botswana, on occasion of the Good case, had made that argument that the Commission's findings are not binding and it need not be compliant with Botswana. We've heard once again the Egyptian government in public sessions arguing that the Commission's findings are not binding. Perhaps this is also an issue that comes up from time to time. In this regard, it is interesting that the Executive Council has reiterated that the PRC must operationalize the subcommittee on human rights, democracy and governance. So there's actually a body within the PRC that is supposed to be driving the implementation, putting implementation on its agenda, and consistently verify and engage with states. That body has never been set up. And the Executive Council has now on a number of occasions called on the PRC to set this body up so that implementation at least can be factored and filtered through a body within the AU structures, which would be the Subcommittee on Human Rights, Democracy and Governance. That has been included as part of Decision 1015. In other words, at least there's this concern. If you read Decision 1015 and you start reading it, you will see that there's much rhetoric that still reaffirms support, strengthening, and observance of human rights. So I suppose there's always much to build on, that in principle, the Executive Council is still committed to human rights, to the strengthening of the system, and it calls on states to report, to support the Commission's activities, and so on. So I think there is certainly that basis of fundamental commitment, which is in the AU Constitutive Act,